My name is Marlo Oakes. I'm the state treasurer. And I've got Representative Ken Ivory to my right here. And we'll just start by quickly introducing folks, just name here in the room and then folks online. So Representative Ivory.
Yeah, Utah State Representative Ken Ivory, sponsor of House Bill 348 that convenes us here. Glad everyone's here.
Sorry, Brittany Griffin, Treasurer's Office.
Susan Spears, Utah Association of CPAs.
Randy Quarles, the Signature Group.
Kurt Slot, Deputy State Treasurer.
And then online.
Jason Gardner, I'm the Director of Legislative. Oh, am I muted?
No, we can hear you.
Yep, we can hear you.
Okay, sorry. Jason Gardner, Director of Legislative Affairs at the Taxation. I'm on my way up there. I got held up in a previous meeting. I'm just parking just this minute, so I'll be there, inside in the meet room in just a minute.
Wonderful. Thank you. Let's see. And then do you want to have Dr. Vieira?
Yes,
Edwin Vieira here.
Great. Welcome. And then Tom?
Yes, Tom Salgas.
Mark follows?
Yeah, Mark follows, Chief Compliance Officer at Glint.
Oh, great. Okay, welcome. And let's see. And then we've got Dan.
Dan Burton with Utah Attorney General's Office. Sorry I couldn't join today. I was a little under the weather this morning and I thought I'd keep that to myself.
Thank you. And Jason. Oh, you're still on mute, Jason.
So yes, Jason Cousins, I'm the founder and CEO of Glint, which is the first company in the world to make gold working transactions, electronic transactions.
Welcome. Joe.
Hi, Joe Cavatoni with the World Gold Council, calling in from overseas.
Great. Let's see, I'm having a hard time reading some of the names here. Christian.
Yes, hi, Christian Chalak, Senator Mike Lee's office in Washington, D.C.
Awesome. Oh yeah, Brian.
Hi, Brian Summers, President of the Utah Mining Association. Sorry I couldn't be there in person.
Okay. Let's see. Larry.
Larry Parks, the Foundation for the Advancement of Monetary Education in New York City.
Welcome. Hugh.
Yeah, hi, Hugh Hannison, a local Utah FinTech CEO.
Kevin.
Kevin Freeman, an economist and authored the book Pirate Money.
And Noah.
Hi, Noah Hansen. I'm a staff economist with the Legislative Fiscal Analyst Office.
And let's see, Chris.
Chris Stitt, Policy Analyst for Legislative Research and General Counsel.
Great, welcome. And then Howard.
Hello, this is Howard Headley with the Utah Bankers Association, and I am also in transit to the Capitol. I'll be with you shortly.
Great. Welcome. Let's see. Representative Moss.
I'm actually here in person.
Hey, awesome.
Sorry, I will be jumping back online here a little bit, but Jeff Moss, member of the House, and happy to be here.
Great, welcome. Excellent. Did we miss anybody online?
Jason Gardner.
Did Jason Gardner? Jason Gardner, did we introduce you?
Yeah,
Oh, did you?
Yeah,
Okay.
I'm just walking in right now.
Oh, there you are. Yes,
There,
Jason.
okay.
That's okay.
So I'll see you in a
Thank
second.
Okay, sounds good. Thank you. All right, so we did distribute minutes from the last meeting. Is there any comments or edits to those minutes? Okay, we don't need to approve them, but just wanted to make sure that we took any input if there was any. All right, so at this point, we're really going to be focusing a lot on capital gains tax and then regulatory issues at this meeting, and seeking input from anybody, actually, the group here, kind of a roundtable discussion in a couple of places. But before we do that, I'll turn the time over to Representative Ivory to give an update on some of the meetings that have taken place since the last time we met at the end of June, And then we've got a special guest that he'll introduce after that. So Representative Ivory.
Thank you, Treasurer Oaks. Yeah, and welcome everyone. So grateful that you're here. What an incredible time. We've had some very fascinating meetings since our last study group meeting. And just looking at where we might go in the study and what next steps might look like for Utah. Able to visit with Judy Shelton, who was the nominee from President Trump to be on the Federal Reserve. And when the 2020 elections went a different direction, her nomination was shelved. She was actually did her master's and her doctorate at University of Utah. So she has a lot of Utah ties and very interested in the work that we're doing, but kind of echoed the same things we're hearing from others, that we're in a serious time in what's happening with the dollar and the nature of the debts, deficits, and trajectory on federal finances. We talked, and Brittany, I sent this to you before. I don't know if you can pull that up or if it's visible at all. Probably not visible on the screen. Oh, there we go. Brittany can pull that up. But more and more, we've been looking into this resolution and the ramifications globally, where the U.S. Senate passed a unanimous resolution that the debt as a threat to national security.
My email.
Yeah, I think I might have texted it to you.
Oh, that would be why I'm not.
I might have
Sorry, give
texted
me a
it.
moment.
But you know, unanimous U.S. Senate resolution, and debts, deficits, interest, the trust funds going to zero in single-digit years. But the thing that really stood out, and particularly in terms of what we're looking at here, is the paragraph where they spell out that China and Europe are developing alternate payment systems to weaken the dominant position of the United States dollar as the reserve currency. In May, the IMF came out and basically announced the end of the rules-based monetary order, signaling things that are happening with the global South and the nations that are aligning with China and trading in that currency. And then there's the BRICS have their big annual meeting in October, that their number one agenda item has to do with payment systems in the dollar. And not to give any of this information as a certainty, but there are trends and things happening in the world. And I think Kevin Freeman mentioned in this discussion that the nature of money is changing. As we were looking into these, Kurt and Brittany and I had a meeting with Thomas Honig, who, Randy, I think you probably know, Dr. Honig, and he was on the Federal Reserve Board of Governors for
President of the Kansas City Fed.
President of the Kansas City Fed, and part of the Federal Open Market Committee, and during the 1991 to the 2011 period. And it was really interesting in all the discussions that we've had. He talked about going to Congress and to Washington monthly. And I think of all the people that we've talked to, he was the most sober in terms of, I think he said pretty directly, no one in Washington has anything about the debts and deficits on their radar screen at all. It's just status quo, print to infinity. And we asked him, so what do you recommend? If you were a state leader, what would you recommend? And he said, I would recommend what you're doing. Make sure you have a solid reserve in a stable store of value. And it was just sobering to hear from him in the way that he did. I talked to the speaker about perhaps getting him to come and brief legislative leadership sometime before the session, but yeah, it was just the nature of things in Washington, just that trajectory, it just continues forward. And with that in mind, we talked before in here about with things that the Senate has signaled and others, that the nature of money changing, that perhaps we need to be looking at, are there things that we need to do in alternate systems of payment? Are there ways that we make sure we can continue paying as a government, paying employees and salaries, and paying for the commodities and things that the state receives? We've had some discussion in here about those types of alternate payment systems, but then we always kind of run into, if we were to do that, you've got the capital gain issue, where gold has capital gain tax issued to it from IRS regulations. With that as a preface, we've had the opportunity to visit with Dr. Edwin Vieira. And Dr. Vieira, I'm gonna let you give your own introduction. I'm sorry, because I've been running back to back meetings. I do know that you've written the biggest book I've ever seen on gold as money, and I've only got one volume of it. I'm still looking to get the other volumes, but everyone I talk to, you are the author of the definitive source of law and matters on gold issues. We had a prior discussion about how, if we were to look at different alternate payment systems, what capital gains tax implications there might be, and ways that a state as a jurisdictional actor and having standing might be able to challenge the capital gains taxation of gold. And with that as a preface, I ask you to introduce yourself and help us understand what, if we were to look at payment systems in gold, what we're looking at and what options might be available for the state.
Well, I'm an attorney, came from Harvard Law. I entered into this area with Ron Paul when he was on the United States Gold Commission back in the early 1980s, and wrote a short paper for them, really dealing with the historical and constitutional basis of our monetary system. And that's somewhere along with the Ark of the Covenant in the archives of the government. Now it kind of disappeared. But he encouraged me to turn that into a book. And so a book came out in 1983. And then that was expanded in the year 2000. That's the book that was just mentioned. And it goes into historical detail, great historical detail about the source of the United States monetary system, and then the historical, what I would call, devolution of the system until what we have today, which is something of a hodgepodge, because you don't really have a unitary monetary structure based on a single unit that has a tie back as a commodity into the free market system. You have gold coinage now, the American Eagle set of gold coins. You have the American Liberty silver coins. You have what I would call base metallic coins. So those are the ones that generally circulate. You have, of course, Federal Reserve notes that are supposed to be redeemed in lawful money. They are not themselves lawful money, although they are legal tender. And then you have a panoply, a hodgepodge of various commemorative coins that Congress has put out at one point or another, which really don't have any significance here, because they really don't circulate. They're things that people will put away precisely as commemoratives and collectibles. Now, the difficulty with this set of units, different disparate units, all of which are denominated in something called the dollar, is they are not commensurate in value, in the sense that they can all be reduced to a single unit. You take, for instance, the position of the Secretary of the Treasury, which is supposed to be maintained statutorily. The Secretary of the Treasury is supposed to require that all forms of the United States currency exchange or have equal purchasing powers. And this goes back to a gold, so-called gold price of $42 2/9 per ounce. All right, well, that's a statutory requirement. If you look at the United States gold coinage, the 1 ounce gold coin is $50 denominated by Congress. That's fairly close to $42 2/9 per ounce, but it's not equal to it. You have the 1 ounce silver coin. That is certainly not equal to 1 ounce of gold, having a value of $42 2/9 per ounce in gold. That's certainly not the case of the Federal Reserve note or the base metallic coinage. I think gold this morning was something of the order of $2,500 per ounce, and that's bullion. So the premium would raise the Federal Reserve, the United States Gold Eagle to a somewhat higher price than that. So that's the first difficulty. You have what I would call a non-rational system. And people keep talking about this thing called the dollar, but there are a number of different units which are called dollars. And it just so happens that the common one that people use is the cheapest, the Federal Reserve note or the base metallic coinage. Now, the difficulty arises if you set up a system which enables people to choose among those forms of currency by entering into what have been called gold clause contracts, contracts that require payment in gold in a specific form. You could also have silver clause contracts. Today, typically a contract that talks about dollars, the court will treat that as a Federal Reserve note contract or a base metallic coin contract. But gold clause contracts became quite popular immediately upon the issuance of the first United States legal tender paper currency in 1862 in the Civil War, because that currency depreciated fairly rapidly. And so people who had a little bit of financial acumen turned to contracts that specifically required payment in gold. And the Supreme Court upheld those against the claim that the only currency that could be used in contractual arrangements in commerce was the so-called legal tender paper currency. So as a result of that, you had gold clause contracts proliferating throughout this country by the turn of the, well, let's say by World War I, to be sure. All the United States bonds had gold clauses in them. State bonds had gold clauses. Corporate bonds, long-term corporate bonds, railroad bonds, 50-year bonds, 70-year bonds, all had gold clauses in them, which related back to the Gold Reserve Act of Gold Coinage Act of 1900. That's standard. So much gold, $20.67 per ounce of gold coined. And that was the system that the Roosevelt administration overthrew in 33, 34. And Congress abrogated gold clauses in the sense of those clauses were no longer capable of being enforced in the courts. So you could write one, you could have one written in an earlier contract, but it couldn't be enforced, so you had to be paid in whatever was legal tender. And of course, people then paid in Federal Reserve notes because Federal Reserve notes had been redeemable in gold, and that redemption was withdrawn at the same period in time. So we went essentially to a non-gold system domestically with respect to both the coinage and the paper currency. And internationally, Nixon took the country off the gold standard internationally in 73. So we're on essentially a fiat currency standard with this disparate set of units that don't make any kind of rational economic sense. So if we look at the situation today, it would be to someone's advantage to make a gold clause contract, because then he's assured, especially if it's a long-term contract, he is assured of protecting himself against inflationary developments, which has been the tendency since the Roosevelt era. But the problem becomes, how does one value one of those contracts legally in terms of a monetary unit? So let's say an individual had a contract that was payable, specifically payable in a 1 ounce United States Eagle gold coin. Now he receives that gold coin as part of his, let's call it income to make it simple. What does he have to report to the federal government on his income tax return? The coin is stamped $50, and that's by statutory order of Congress, which designated as $50 and legal tender for $50. In the marketplace, the coin exchanges for, let's say, 2,500 Federal Reserve note units. So is the monetary value of that income that he received 50, or is it 2,500? Now, the IRS takes a position that it's 2,500 because, according to them, gold coinage is not really money, it's something else. I don't know what whatever word they want to use for it, but it's not money. Notwithstanding that Congress has made it, has ordered to be coined, has given it a legal tender value, has given it a face value. It's not money. So you run into immediately that problem. The desirability of making these kinds of transactions is seriously undercut, and people are deterred from doing it because they run into this tax problem. Now, I would look at it from the point of view of saying, well, the IRS doesn't have any authority to demonetize one form of the United States money. If Congress declares a gold coin is $50, it's $50. If Congress declared a Federal Reserve note through the machinations of the Federal Reserve System, the Treasury, to be $1 or $5 or $50, that's what it is. The same with the silver coin. $1 American Liberty silver coin is $1, notwithstanding that the IRS might claim that it's $20 or $25, whatever the market exchange rate is. But that really complicates the use of these alternative currency methods, especially if you get into the situation where you're not exchanging dollars in the contract, the gold clause contract, but you're exchanging, let's say, grains of gold. So you had an exchange system whereby the bank, as it were, was maintaining gold in its depository, and that gold was valued in troy grains. And those were the units that were being transferred back and forth. So you're not even calling those things dollars. They might have a dollar value, but which dollar value? Dollar value in Federal Reserve notes, dollar value in silver dollars, dollar value in gold dollars. Then becomes extraordinarily complicated for dealing with the federal government. Now, I don't think it would have any complication whatsoever for dealing with the state government. The state government can rearrange its taxation system any way it wants. But overarching the state is the United States Treasury Department and the irrationality of that entire system that has been created in conjunction with the regulations of the IRS as to how those units ought to be valued and to be taxed. And that, of course, includes the capital gains taxes and probably other taxes that we can imagine, valuations that would be used. Well, how does one go about attacking that system? And the difficulty that I mentioned the other day was the Tax Injunction Act. A taxpayer cannot go and preemptively limit the IRS's use of these regulations because the federal courts treat that act as precluding them from exercising jurisdiction for declaratory judgments. You can't go in before the fact and get a declaratory judgment that the IRS's imposition of these regulations when you would get around to filing your yearly tax return is improper. And it can't, the courts say that they cannot exercise jurisdiction with respect to injunctions. So one can't stop the IRS from making collections according to these regulations and doing other things that it does if you fail to abide by the regulations. So really the only practical choice, and I would say from a risk-averse position of an attorney, the only really safe choice is for the party to pay the tax amount that the IRS requires according to its regulations, do that under protest, file a case thereafter in the U.S. District Court, seeking a refund on the basis that the IRS regulations are invalid, and instead of paying that $2,500 or putting in whatever line item it is, instead of putting $2,500 into that line item, you only had to put in $50. Now that would tend to solve a lot of the problems that we might become involved in. But the difficulty is it has to go into what I would imagine would be extensive litigation, because you're not only talking about the district courts, which would probably uphold the IRS regulations, but then you're on your way to the appellate courts. There's another couple of years, and potentially you're on the way to the Supreme Court as well. And the Supreme Court has not done very well with monetary problems. And I give the example here of one in the area of the Roosevelt era, 1933 and 34. You know, the abrogation of the gold clause contracts, and this was the follow-on to the seizure of gold. Because remember, the first thing Roosevelt did when he came in March of 33, he froze all the banks and stopped gold redemption of currency. So the Supreme Court took on 4 cases that involved the abrogation of gold clause contracts. And with respect to private contractors, said that's fine, Congress has the power to do that. With respect to currency, gold certificates, as they would call them, the Supreme Court said, yeah, that's fine, Congress has the power to do that. But with respect to U.S. bonds, Congress said, no, Congress did not have the power to do that, where it would result in a loss of actual purchasing power to the bondholder. Unfortunately, the bondholder couldn't get that purchasing power because there was no way he could get his hands on the gold, and that's the way they solved the problem. They said, well, if the government gave you the gold, it would just simply seize the gold on the earlier gold seizure, and you would only get the face value of the bond, not the actual gold. So although Mr. Perry won his case in principle, he lost the case in practice. Now, the interesting thing there is that the Supreme Court never decided the question of the gold seizure. Although at least one case was before them raising that issue, the court refused to take it. And it decided all the other 4 cases based on the predicate of, we don't have to decide the gold seizure because it's not here. So I always look at that as one of the really worst decisions the Supreme Court of the United States ever made, because the abrogation of the gold clause contract, as it turned out in the Perry case, the reason the government won that case was because of the gold seizure. So I don't think the courts have a very good record on this. And there's one of the difficulties. Also, you need a particular taxpayer to challenge the system. The state can't do it directly because the state doesn't have standing. The state's not paying that tax. Exactly how the state would bring a suit, potentially, might involve the exercise of the reserve powers of the states to make gold and silver coin of tender and payment of debts. That is, set up a state gold and silver payment system, and not impair the obligation of contracts, the other side of that being to enhance the obligation of contracts as much as possible. And we're speaking there, of course, of gold clause contracts. So you could take those 2 reserve powers of the states and try to generate a case that would be challenging the Secretary of the Treasury directly and indirectly the IRS under him, because he approves the regulations dealing with what I just talked about. Now, the difficulty there is, what's the statutory basis for exercising federal question jurisdiction? There really doesn't seem to be one. I suppose I have to look a little more deeply. And the way those questions were often handled in the past was something called Bivens litigation. The Bivens versus, I don't remember how many agents of the Federal Bureau of Narcotics. They violated his 4th Amendment rights, and he brought a suit under an implied cause of action, as it was called, under the Constitution of the United States directly, saying, well, these people had violated their oaths of office and certain statutes that they were supposedly enforcing. And although there was no specific enforcement statute for what Bivens wanted to do, the case could be brought directly under the Constitution. Well, recently the Supreme Court heard a case that pretty much gutted the Bivens concept, pretty much said that the only case they ever want to hear, or ever will be heard on that line, is the Bivens case itself. So you have some difficulty there. The state may not be able to get into the process because there isn't a direct cause of action. And an individual, of course, has to go through this lengthy process of paying the tax under protest, suing for refund, and going up the long ladder of litigation to a Supreme Court, which ultimately I think will be relatively unfavorable because they see the consequence of it. You see, if I were on the Supreme Court and someone brought one of these cases to me, especially one that raised constitutional questions about the Federal Reserve System and its currency and the relationship of its currency to gold redeemability or whatever, they're all tied in together, I would be very reluctant to want to grant a petition for certiorari, because I would say, well, wait a minute, I might be able to find this system in whole or in part unconstitutional, but I can't tell Congress how to correct the problem. I can only give a negative on this system, but I can't give it some kind of positive direction. And then, of course, what happens in the markets 5 minutes after this opinion comes out, when they suddenly realize that the opinion has thrown a monkey wrench or created a great deal of potential destabilization in the monetary and banking world. So it's very unlikely that the court's going to want to insinuate themselves into this, stick their nose into this problem, because they can only create difficulty. They can only throw a monkey wrench into the process and then leave it to legislators to try and correct it, while the markets are reacting in probably a very negative fashion. Now, that doesn't mean it shouldn't be set up. I mean, if we're talking about a state reserve, simply a reserve in gold and silver, for instance, as an example, that's fine, because that's a financial investment against the hard times of monetary depreciation. If you're talking about immediate exchange, then you're talking about a system of gold clause contracts. That is, parties dealing with the state, they might be employees, they might be contractors or whatever, would have to agree to, the state would agree to very specifically worded gold clause contracts that could not be satisfied through the payment of paper currency or junk junk coinage, that type of thing. And those gold clause contracts, although they're completely legal, we don't have any real litigation on them since the 1930s. I mean, people haven't been using these things since their effectiveness was abrogated by Congress. So we don't know how the courts are going to treat them. We do know how the courts treated them after the Civil War, because those types of contracts were made on a regular basis, and a number of them came to the Civil War. Came after the Civil War to the Supreme Court, and the Supreme Court ruled in favor of them in every instance, especially the point that those contracts had to be specifically enforced. The courts could not enforce those contracts through the payment of paper currency damages. They had to be enforced specifically through the payment of gold or silver. Primarily, they were gold clause contracts. And that was a really stabilizing effect of those types of instruments. So you have all of that. You have all of that precedent, if you will, in the late 1800s. It was never questioned in the 1930s. It has never been looked at since by the Supreme Court. So one could say, well, the record is very clear that these kinds of contracts are allowable, even given the bipartite system of legal tender paper currency on the one hand and gold and silver coinage on the other, because that was the system immediately after the Civil War. And it's never been questioned. But once again, the Supreme Court has been known for overturning itself on constitutional issues whenever it finds earlier precedents inconvenient or otherwise. You look at a case called Perry versus Tennessee. I think it's 500 Supreme Court, volume 5 of the Supreme Court reports, page 1. And you see the first footnote is a list of all of these cases. The Supreme Court has reversed itself. So it's not something they might not do, especially given the fear that I think would be expressed in the back room of what the consequences might be if they, what shall I say, followed exactly the line of decisions that had been promulgated immediately after the Civil War. So we have a political problem as well as an economic problem. You can say, well, the whole monetary system is going to hell without a handbasket. But the courts probably don't want to stick their hands into the machinery because they may find themselves, as it were, chopped up by them.
So that's the key question then, Dr. Vieira. I guess, would you take a few questions then?
Well, I think if you're going to do it, you're going to do it. And you take your chances. The worst that happens is the Supreme Court denies certiorari or says, no, the IRS is correct. They can do this on some theory that's a cockamamie theory that the Treasury generates, and you're where you are now. So I don't think you're in a situation that's worse off.
If you take a couple of questions. I just want to kind of recap to make sure I'm understanding this and then see if you would take a couple questions. So the problem that we have is, as a state, we're having a hard time paying employees because the value of the dollar is devaluing, and the private sector can close that wage gap and pay people higher faster. And so we've got a wage gap trying to retain employees because of the issues with the dollar. We have issues going forward that all the commodities and things that we buy are getting 10% more expensive a year, and that's all a function of the dollar and then in the investments. So from what you pointed out, we've got in the Constitution, Article 1, Section 10, that says as a state, we're not supposed to make anything but gold and silver legal payment in tender of debts. And then as a state, we're not supposed to impair contracts. And yet, as you pointed out, the value of contracts getting paid back in dollars that are worth less and less with each progressive year. And so where we're trying to look at a potential contingency planning where we might have an alternate payment system to retain employees in an emergency, or be able to buy goods that may be needed if the dollar continues down the path of the trend on the value that's happening. So what I'm hearing you say is, I think I heard you say, there's not a case on point of a state challenging these types of things where the impairment of contracts or the gold and silver as legal tender is there's not precedent, or what is the precedent like in terms of a state trying to uphold that clause where they would hold gold and silver as legal tender, and perhaps even uphold the contracts clause where we're trying to uphold the sanctity of contracts. So what is the precedent look like for a state taking that kind of action? And I think just from there, if you could look at that question.
Well, once again, going back to the 1800s, late 1800s, post-Civil War, there was a case, Lane County versus Oregon, in which the Supreme Court recognized that a state may determine for itself what it wants to use as currency, money, in the exercise of its sovereign functions. And that particular case dealt with taxation, that a state could demand to be paid in gold and silver as opposed to, at that time, United States legal tender irredeemable notes. And the argument was made on the other side that no, Congress has generated these notes, and these are now, quote unquote, dollars, or they're instruments valued in dollars, and therefore the states must accept them in payment of taxes, even though in Oregon at the time, only gold and silver was allowed under state law to be collected as taxes. And the Supreme Court said, no, notwithstanding what Congress has done over there in the monetary field, the states retain sovereign authority in certain functional areas. And what would those be? Well, taxation would be one of them. Employment of people or contractors performing state functions, borrowing, another one, spending, another one. You think it's the major state functions would all fall under that Lane County versus Oregon argument. And therefore it's conceivable that on the state side, the state could say, well, we're only going to receive gold and silver, or we're only going to pay gold and silver, or both. And that would be the end of that as far as the state's concerned. And I don't think anyone could come in and say, no, a state is required to use this other medium of exchange that Congress has created, this non-gold and silver medium of exchange. And that's just simply on the basis of that decision. Because you can add to that Article 1, Section 10, Clause 1. No state shall make anything but gold and silver coin a tender in payment of debts. Whose debts? Everyone's debts. There's no limitation on the word debts, all right? So you have that, and you have the fact that state gold clause bonds or gold clause contracts were never abrogated. Although in theory, I suppose the congressional resolution of 33 would have covered those. But the Supreme Court never heard a case saying that that was the result. The states seemed simply to have acquiesced in this and walked away from the problem. So you're really not precluded by a negative Supreme Court decision, and you have a positive Supreme Court decision on the state's authority with respect to its sovereign functions to use its own choice of medium exchange. And then you have a number of Supreme Court cases dealing with the legitimacy of gold clause contracts and how they have to be enforced in the courts. So I think this really, the problem really comes down to the fact of to the person who's receiving, the receiving individual, the employee, the contractor. He's getting this, and all of a sudden he has to have another accountant working for him. He receives this gold. Here's the value of the gold. There's the basis of the gold. Now he starts liquidating the gold thereafter, and he has all these calculations that have to be made, which don't have to be made with respect to Federal Reserve notes or base metallic coinage. So he has another accounting problem, practical problem. Not that it can't be done, not that the accountants can't work out the books, not that the computer programs can't be arranged to solve all of those difficulties, but it's another complication for him. So the question becomes, is it worth more to the recipient to have a steady income or payment in gold or silver because he's afraid of constantly depreciating values of paper currency? Is it worth more to him to do that than it is to have to pay for the extra accounting costs of eventually reporting all of these transactions, whether it's income or outgo, with respect to the federal treasury? And I would think in the period of hyperinflationary event, yes, it would be, no matter what the accountant costs. right? The accountants cannot cost as much as the depreciation of the currency, the losses from the depreciation of the currency. So you'd probably jump on board gold clause contracts under those circumstances to be sure. But of course, it's right now, what's the likelihood that enough people are going to see this as a valuable defensive mechanism? Most people don't understand what's going on now. Well, inflation to them is the change in the price of a box of Cheerios, right, in the grocery store. They don't understand why that's happening, that it's all tied back into the monetary system. And then they're told that the way to solve this problem, keep the price of Cheerios low, is by price controls, as if that had any relationship whatsoever to the banking system and inflation of the currency. So there's one of your difficulties.
If I could, Dr. Vieira, I wish we had an hour to go down all of the different strings that you've pulled out, and we need to do that and love to follow up. I don't know if there's any question from any of the committee members that we do need to follow up with you, absolutely. And I believe you said there's no congressional act that makes gold that deals with the cap gain tax. That was just an IRS regulation. It wasn't an act of Congress that made gold subject to capital gain tax.
No, I haven't seen one specifically. They treat it as collectibles.
As a matter of fact, Ken, Title 26, Section 408M, as a Mike, 26408M defines gold coins or gold in general as collectibles, but specifically exempts the U.S. minted gold coins and silver coins.
Yeah, so.
And then if you go over to 26 1 and you look up for 408M, you'll see that those collectibles are not, U.S. coins are non-taxable, but the IRS doesn't treat them that as gold coins minted by the U.S. They just treat them as gold bullion. And it's a semantic difference, but the law is very specific. And so the IRS by regulation has been doing something that is not in the statute.
This is fascinating, gentlemen. We definitely need to follow up more offline. We do have a question from Randy Quarles, Dr. Vieira.
So just listening to sort of all this together along with the discussion from the last session, if the issue is the capital gains tax, and I thought I understood your argument was that there would be a good case that notwithstanding the IRS position, the law actually, you could win a case that U.S. minted gold coins were not subject to capital gains tax. And we go back, I think that last session, Jason Cousins had said Glint could use anything, but they chose to use gold. Could you get around the issue of capital gains taxation by having the gold that's traded through Glint or through an analogous platform or some sub-platform of Glint being gold coins to say, okay, well, we're trading fractional interest in these gold coins or multiple coins that will be exempt from taxation, even if you didn't think that you could succeed in getting a capital gains exemption on fractional interest in bullion itself. So that's, I expect people don't have an answer off the top of their heads, but the question is that a worthy question to explore?
Well, let me go back one step. The receipt of a $50 gold coin is a taxable event. It's my income in the example I gave. I'm the employee, I'm paid $50, I receive this gold coin. The question is it $50 or is it $2,500 that I report on, schedule whatever, line item 5? That's the first question. The second question then becomes the capital gain. After I paid whatever my income on that thing is, now I have the $50 gold coin. It appreciates. Instead of being $2,500, it's now $3,000 when I exchange it. Have I now a capital gain of $500 on that transaction or not? You don't have a capital gain on Federal Reserve notes going up or down, capital loss, capital gain, and nobody even thinks about that. Impossibility, right? So why should it be true for some other form of United States money? And the answer was it shouldn't be. So it's at both levels versus what's the valuation of that coin, that piece of gold, when I initially receive it in terms of my income, and then assuming that I'm holding this thing over a period of time, do I have any capital gain or loss because in terms of Federal Reserve notes, it appreciates or depreciates? So you have those two elements. And I think in both of them, the IRS is wrong. The IRS can't do the capital gains in the long term, and the IRS can't assign this fraudulent value to a coin which has been given $50 face value by Congress. That's the difficulty. Now, they've done it for an obvious reason in the background, in the back room, is because they don't want people using gold and silver coinage as an alternative to the banking currency, legal tender paper currency.
And yet the challenge, the more they devalue, the more that, you see the Bitcoin and other things popping up to deal with the very issue that the money is eroding out from everyone's feet. We definitely need to follow up with you a great deal more, because as we're looking at, from what Congress has told us, that there is adverse pressure on the dollar and IMF and others, that for us to make sure we can buy goods and pay people, we want to make sure we have the ability to do that. And this is obviously a tremendous issue in moving forward on that. That is a major issue we look at as we're looking forward to legislation in the next session. Any other questions from the committee? That was an excellent question, by the way. Who did, Larry?
A couple of things come to mind. I don't know if it was a federal court decision or
Could you
not.
get closer to the microphone? We can't hear you.
I don't know if there was a federal decision on this, but I recall that after the gold close contracts were reauthorized by Congress in 1977, that people who had long-term leases, say 99-year leases, I think there was at least one case where the renewal came due after gold clauses were reauthorized, and which had a stipulation in the lease for a gold clause, that the gold clauses were upheld in a court action. Edwin, do you recall about that? And is there something to do with that?
Yeah, there were a number of those in which they lost.
Jamaica Ave.
Yeah, and then there was one that was a renovation, a renovation of contract. And that's it was a peculiar situation, because there was a group called the Gold Bondholders Association that were trying to have the courts recognize that once gold ownership was re-legitimized and once gold clause contracts were re-legitimized, that these old contracts somehow were rejuvenated. They came to life again. And in all those cases, the court said, no, they don't, because the statutes of Congress didn't reach back. But this particular situation, because of what the parties did, there was a renovation of the contract. There was a change from the old contract into a new contractual provision, and that triggered the gold clause as a new element coming after Congress had re-legitimated those clauses in 77, 78. So it's a peculiar situation, which, I mean, you'd have to have essentially those exact facts, that exact pattern of activity to gain from that precedent.
Yeah, quite a dilemma. Kevin Freeman, we're going to give you the last question or word on this, and then we need to move forward on the agenda. And then Dr. Vieira, thank you so much. We are so grateful for the time that you've taken on this. We definitely need to follow up and look forward to digging into this issue more going forward, because obviously the devaluation of the dollar doesn't seem to be going away anytime soon. Kevin, go ahead.
Yeah, Dr. Vieira, I wonder if you could comment on Bronson versus Rhodes and the implication for the distinction between bullion and coin.
Well, the Bronson case is very interesting because it points out that there really is no distinction in the long run, that coinage simply has the imprimatur of the government impressed by a stamp telling you about the purity and weight of gold in that particular coin, whereas bullion requires what they called in that case assay and the scales. In other words, you had a piece of bullion, chunk of bullion, and it didn't necessarily have stamped on it its weight and purity. But if you look at the practices today, is there really a practical difference between bullion coming from reputable sources and coinage coming out of the government? And on the basis of what the Bronson case said, and a couple other cases that followed on and quoted it, one would say, well, no, bullion can be used just as well as coin can be used. There shouldn't be any real constitutional difference as long as the bullion has some kind of certificate of weight and purity that has at least as good credence to it as what would come out of governmental mint. So I think we're not limited to coinage. I maybe should have made that point before. We are not limited to coinage in dealing with this situation. We can also use bullion. And if we can use bullion, then we can use aliquots or smaller units to get down to the troy ounce or the troy grain. Why not? What's the difference?
Excellent discussion. This leads us very directly into the next discussion, and you're welcome to stay. Grateful to have you with us, and we definitely want to follow up that what we've heard and taken is there may be a road for a state as an actor with jurisdiction to potentially address some of the issues dealing with capital gain in an alternate payment system of gold under the impairment of contracts and under the gold clause and the reserve powers to the states, as you mentioned. And definitely that's a lot of the work that this committee's been assigned to look into. So we definitely want to follow up with you on that. As you mentioned, then into the transactional realm of how the state may move in and helping to facilitate an alternate payment system. We've had some meetings with the tax commission on what that may look like for the state receiving payments of taxes in precious metals, and then what that may imply in actually the state using or engaging an alternate payment system. And I think, were you prepared to kind of recap some of the discussions we had? So we were talking about if the state were to receive payment of taxes, severance taxes, other things in precious metals, what that might look like. And if you'd go ahead and just introduce yourself again so it comes through on the mic.
Sure, Jason Garner, Director of Legislative Affairs and Tax Commission. The discussion we had was using a model that was developed several years ago to deal with actually Bitcoin. Currently, you can pay your taxes in Bitcoin. That's the current status quo here in the state of Utah. And so using that model, basically what it does is there is a service provider set up with the Department of Finance is where it's currently housed. And you would go through this portal that's available and make your payment. Now the taxes themselves, what the tax commission actually receives will be US dollars after the conversion, because that's how your taxes are going to be calculated. We can't have a parallel system of calculation of taxes in separate currency forms. Just like if anyone tried to pay in euros, it would be no different to us. They need to convert before bringing it to us. But we have a portal that would make that possible. That if someone had their assets in gold without having to go through some, come in and bring dollar bills to us, they could use this portal to pay directly. Everything happens behind the scenes and makes it so that we essentially receive US dollars. Now, one thing I have to say though, is the way the IRS would recognize that transaction. They would still recognize that transaction as a capital gains transaction based on the difference between when you acquired that gold and use that gold to purchase any services, whether it be pay your taxes or buy a Starbucks coffee. It doesn't matter to them what you're purchasing. That would still be a taxable transaction. So it would not avoid the capital gains on this, but it does make it more convenient, and it's making it so that a person could make that transaction in gold here in the state.
Well,
interesting, but that becomes a liquidation then at that point. So if I'm using highly appreciated gold to pay taxes, I get a liquidation and then a cap gain tax on whatever the income tax.
Absolutely. It'd be no different than if someone liquidated stocks, bonds, barrels of oil for purposes of paying their taxes.
So how would that be, Brian? I don't know if I can put you on the spot, Brian Summers. If a miner were paying a severance tax, or if they were, paying a severance tax in gold, and that's just directly coming out of the ground, I'm assuming that would be if they're paying a portion of what they excavate, what they take, what they, in the severance. I'm assuming that capital gain tax may not apply on that portion.
It's an interesting question. I don't know how the IRS would view the capital gains on something that they acquired without purchase, right? Like they, and so, I'm not sure whether there would be a capital gains in that circumstance, but definitely.
But a minor might have an income tax on that.
Right,
The difference between the, the cost of the ground and the value of what they're essentially transacting.
Right. Hey, Brian, would you kind of comment on that? And then, in general, any appetite or interest in a mining community or any other communities that to pay tax directly in the commodity converting to dollars?
Yeah, I mean, I actually had that exact same question, Representative, is, how would this be treated from a capital gains perspective when, you're dealing with a producer who's, actually producing the gold? And in the case of some of our Utah producers, I mean, that's, a vertically integrated operation. So, I mean, they're going from, ore to finished product, 99.999% pure gold within the same operation. There's no outside contracts or anything. So I think that figuring out the answer to that question in terms of the capital gains aspect would be really important. But I think also the other thing would be, as we've talked about in the past, if somebody wanted to, pay their, portion of their severance or income or other tax obligations with physical gold, to where they would actually be delivering a physical product to the treasurer, to, a repository of some sort. How would that work from the tax commission's perspective? I mean, I appreciate what's been said about, using a portal that would be similar to what you use if you want to pay in Bitcoin or whatever the case is, where that's essentially an electronic transaction. But, if a producer was interested in bringing physical gold to a repository for their payment of taxes, how would that work from the tax commission's perspective?
We wouldn't have the ability to accept direct physical gold or the expertise to value it on the spot without great, incredible cost.
Well, you wouldn't have to do it.
Yeah.
It would go through a Brinks vault.
And it goes through someone else.
The state would have an account with Brinks and they would simply transfer a portion of their Brinks account to our Brinks account.
And then that
would be the extent of the transaction.
And if you're providing us a dollar value of that transaction so that we can credit their tax account with, then that would.
Well, I think the value behind it would be valuing a transaction in gold. So if there's severance, it's a percentage of gold. The value would be in not having to liquidate it to transfer it. It would be in valuing it in gold and then transferring it in gold. That would be the value of once you liquidate, there's no value to the transaction for the producer.
Then we'd have to completely create a parallel tax system for every tax in gold. Because there's no way because all of our taxes are calculated in gold, calculated in dollars, they're based in dollars, the whole foundation of them is in dollars. And we'd have to completely duplicate the entire system.
For the money.
Interesting.
Yeah.
But in severance, if the severance is a percentage of dollars, would it just be a percentage of the commodity?
So would it be the same thing for, extraction of lithium?
Interesting. Yeah, I don't know, but in the code, I mean, if we did it, we'd open up the payment of taxes in precious metals, though.
Right.
Yeah, no, it wouldn't work for those other.
And then it would just go through the portal. Brian, is there interest in the mining community in general? I know that there've been some others, the Goldback folks and others have long been interested in payment of taxes in precious metals and some others, but in the mining community, is that something worth exploring?
I think that there's definitely I don't know how to say it, Representative. I mean, there's definitely curiosity, because I think that, people can recognize that, especially again, when you're, producing this commodity, if there's a benefit to them and to the state and, paying their taxes directly with that commodity that they're producing, I think that there's definitely a curiosity and an interest in it. I think it's just, figuring out some of these technical issues in terms of, how would that work? again, is there any benefit to, to them doing that? And we've talked in the past about, if the state is going to procure physical gold, for a portion of the, the rainy day fund or other state assets, and they can do that directly from a producer as opposed to having to go through, a broker and pay transaction fees and other things like that. I mean, could that entail some, small consideration on the part of the producer to say, we could give you essentially a discount on your payment because you're saving the state money by not having to go through and procure the gold through, through other sources. So I think there's definitely an interest. It's just a matter again of, what does this look like from a, from a practical perspective? And then also, are there other potentials in the future for, having gold-backed, reclamation bonds and other things like that that could be very beneficial in trying to, hedge against inflation for the mining industry.
Yeah, that sounds like I'll ping you and reach out. I take off Friday for a week-long trip, but sometime the following Friday or after, let's coordinate our calendars and get with Marlo's staff as well and kind of dig into this before our next study group meeting. That sounds like an area to drill down on, and tax commission, we can kind of work with you to see what that might look like, but I think that's an interesting area to explore. And,
that would be great.
And then Joe, is Joe still on World Gold Council? And Joe's right there. Yeah, Joe, would you kind of share with us some of the things that you share with us offline about the cap gain taxation,
Sure.
precious metals that you
look, it's
national level?
It's a bit of a headache across the board, and even just listening to this whole discussion has just prompted me to know that the work we're pushing for is actually in the right direction. There's a couple of things that I share with the group. There was a question around whether or not a digital version of gold would get around any of the actions on the part of the IRS. I can only speak from experience of what we have in terms of dealing with a lot of different wrappers on a lot of instruments, including gold and others. The IRS will look through. That's what their precedent, that's what their behavior will be. They'll look to say you can't use an instrument that's giving one-for-one type of exposure to something. So expect them to look at it the same way that they would on the underlying asset. So you can't get around capital gains on the basis of a wrapper, whatever that form is. It's unfortunate, but that's just the case of how they've set everything up. They do that with exchange traded funds that have gold. So, we've tried to argue that their equity is not gold, and they say it doesn't matter, look through and treat it as gold. But one of the ideas that I had mentioned, in addition to the idea around tax, and I think, Brian, you'll find that the producers are likely not subject to any capital gains because they're producing, they're not investing in the gold. So they wouldn't necessarily, when they would sell their gold, they wouldn't be subject to capital gains. But I like the idea of looking at whether or not, and again, mechanically, it's very challenging, whether or not it would be something that they could actually structurally put in place. But the other idea that I think I'd mentioned was to pursue something along the lines of just making a step forward to get the system going and get the ideas flowing and actually prove the case, which is to consider the possibility of appealing for a de minimis amount. On any given day, you can simply say, we're going to carve out a dollar value that could be used by an individual in the form of payment, and therefore the IRS may be willing to give you that de minimis amount to avoid having to be even throwing that dollar amount into calculations for capital gains. I think that was probably the one idea that I hadn't heard about anybody saying just now, and I thought it would be good to put it on the table. But it's something that I think in the crypto world, they're trying to make a case for. And I think in the case of a digital version of gold or the use of gold in the form of payments, it could be considered. And again, I think anything that's going to be done with either the IRS or legislators in Washington is going to be a very long and challenging battle. So I would suggest maybe thinking about some things that you might be able to get to shorter term where you can prove the case and actually get some traction and get some momentum.
So Joe, the de minimis issue that you brought up, how would that play out in the scenario where we're looking at the potential of having alternate payment system for state employees, state procurement, that sort of thing? how does that then play in if we're trying to prepare that sort of thing? Given what looks like some of the unfortunate trajectories on, dollar value.
Yeah, I think where it plays out particularly the most, I think, is probably in the system that you use to track. And I think that ultimately, I don't know, maybe Jason has some views on this from the Glynn side, but I think it would necessarily be needed to be built into a system where you're actually allowing those payments to be tracked and traced. And I think ultimately that would be how you kind of calculate it in. And ultimately, like an ATM would say to you, you can take $500 out a day. It would basically be a similar kind of construct where the system would have to have some control on that. I haven't seen it implemented, but I think it'd be an interesting one to flesh out further and see if there's a possible way of getting it coded into the system that you're going to approve as the system for payment.
And then the other discussion we had with Dr. Honig was the political potential if there was a change in administration. Have you had any insight or thoughts on that? I think it was Judy Shelton that told me that President Trump received some number of gold bars in payment for rent on one of his buildings, and that he has some keen awareness on the capital gain tax issue. But is that anything that you all have explored or looked into, that what the political potential is and how that might play out?
The other question for me?
Yeah.
Yeah. We're watching closely with bated breath and to see what's playing out in terms of the political landscape. Not very clear, but we definitely think there's an administration that might be more interested in ideas beyond just the dollar. And I think that we'll see how that plays out, but we haven't done much work on it to see if there'd be any move in a very significant way. What we have been working on is working pretty aggressively on the Hill to socialize the idea that the capital gains tax at a collectibles rate is not appropriate. We've made the argument that at a maximum level, we should be in line with bonds or equities. There's no reason to treat gold and bullion, whether it's an Eagle or Kilo bar or a large bar format from the LBMA, the same way that you would treat a collectible, some sort of Persian rug or a piece of art. It's not the same. And when we get into this discussion over what's a collectible versus not, if you simply apply a very basic rule, if you take whatever it is that you think is a collectible, cut it in half, have you impacted its value in any way or not? And if you do that with a collectible coin, you've destroyed that premium that would come to the price of the numismatic or the intrinsic value of the gold. And I think that's what we've been appealing, was to say, hey, look, treat it all like an investment, treat it all in line with other investments. But we haven't pushed beyond that just yet.
I've never heard of the cut it in half test before, so I've got that to go tell my wife what I learned today. So
it's a simple thing.
Joe, that I like it. I think it's great. The same thing, that this is really just a regulatory. It's not the capital gains taxation is a regulatory animal, not a congressional.
I think candidly, I think it's a mess. And I think Tom brought up section 408M, and we've been arguing, debating and talking about, even allowing precious metals, gold, silver, platinum, palladium to be invested in by mutual funds. If 408M doesn't give them the permission to do that just yet, we're trying to get that approved. We're in good shape with that, but it's a regulatory issue at this stage. And I'd say it's probably best to be careful and cautious before you open it up and make it a political issue.
Right. Well, we're grateful we've got your insights and the things that you've been doing on this. Kevin, you got a question or comment?
Yeah, I've actually got 4 comments. I'll put them in rapid fire order. Number one, regardless of capital gains, fighting it is the moral right thing to do. It is immoral to tax money. It's immoral to tax the maintenance of purchasing power. This is something a state should do, standing up for the morality of its citizens. There's a constitutional basis for it. Number two, the IRS code that allows it to be taxed, they're very clear, and they've written papers on Bitcoin, and they say Bitcoin might be legal tender in some instances, but it's not legal tender here. although it does function as currency. And so they've been open to the concept that Bitcoin would be functional currency, meaning you could do your accounting in it. You could pay your employees with it. You could buy a stick of gum with it. You could buy a house with it. Functional currency is one of the two requisites that they say, but it's not legal tender, so it's exempt. Gold can be made legal tender by a state, but it hasn't functioned as currency. If you put those two together, there is a high probability that the IRS code, which is prepared, it's been written in preparation for central bank digital currency, might be considered exempt under existing IRS
Oh, Kevin, we've lost you right in the middle here. Let's see. I think he was. right
Okay, I'm
there.
back. Can you hear me?
There we go.
I'm sorry.
Right at the good part.
I apologize. So that is the second point. The third point is if you implement this at the state of Utah level and it becomes popular, it may be that Congress will act to exempt. Congress is looking to exempt tips from taxation because of the popularity of it. Congress has not banned Bitcoin, even though the government would like it to be banned because of the popularity of it. So actually moving forward could create the popularity that would enable Congress to act. And finally, fourth, KPMG currently has a capability to keep track of all transactions being used on the Glint app and to give you at the end of the year for $35 a capital gains report. So if you're lucky enough to have a capital gain, you can have a report that's filed. And you only have a gain if you've actually seen a gain, and until Congress decides to tax unrealized income. But currently, you only have a gain if you've realized a gain. So sure, they'll tax away some of your maintenance of purchasing power, but not all. And therefore, it is a moral and right thing to do. So number one, it's the moral right thing to do. Number two, functional currency may exempt this from taxation under existing IRS code. Number three, if it's implemented, Congress may find it that the people love it so much, it's extremely popular, and therefore they might decide to tell the IRS not to tax it. And number four, even if it does get taxed, you will only lose a portion of the gain that your maintenance of your purchasing power. And KPMG has the capability now for $35 to produce a report that you could file at the end of the year. So Edwin Vieira's concerns about that have been addressed by Glint's actual functioning and agreement with KPMG. So those are my 4 points. And I apologize, I have to sign off. We're hosting a private screening of the Reagan movie here in Texas. I have John Voight, who's appeared in video, and I've got to go and do that. I strongly encourage everyone to see the Reagan movie.
Segue to the functional currency aspect that we want to come to Glint on. I do want to mention that there was a very fascinating precious metal conference at Kevin's Ranch in Texas a couple of weeks ago that I was fortunate to be there, and Treasure Oaks zoomed in and spoke at, and Jason Cousins was there. And the best part was they named the vanilla ice cream machine after me. So I think I've arrived. That's kind of hit the pinnacle in life. Don't need a building.
If we had Representative Ebony there, though, we would have named the chocolate after him. Ivory, you got to name the vanilla after Ivory, right? All right. Thank you all. See you all later.
All right, Kevin, thank you very much. And so there are many states looking at this in terms of the popularity and the impetus that could push Congress. I think there were 15 states represented at the conference that he had. So Jason, that kind of segues perfectly right into the last item on the agenda, that look at engaging a functional gold alternate payment system like Glint. What do we need to consider? Security considerations, audit considerations. What is the spectrum of options that may be available if the state were to look at engaging some kind of a functional platform like Glint? I think you're muted, Jason, and if you would, as you begin, if you would identify yourself.
Yeah, hi Ken, hi everybody. Thank you for inviting me to speak today. It's a pleasure and a privilege. Yeah, I'm the founder and the CEO of Glint, which is the first company in the world to make gold transactional and real-time and electronic payments. I think that I hear this question a lot across different states who are interested in this type of thing. And I think it's really important to understand that this is not just about technology. It's not just about security. It's not just about the vaulting. But actually, it's very deeply about caring about and protecting the clients. And actually, that is something that's been very much codified into regulations that already exist in the United States. And I just want to make it clear that, Glint is already up and running, and we're completely compliant with all the rules that exist. In fact, what I'm saying is the infrastructure exists, and through the licensing relationship we have with our issuing bank that allows us to issue our MasterCard, it brings our company, and it would bring any supplier to the state, in scope with a number of requirements, a number of regulatory requirements that are very much at the end of the day deeply focused on caring about and protecting those customers, because at the end of the day, that's the most important thing. But it's not just about security. It's not just about audit. It's also about, being very fair and transparent, not being misleading for the customer. And there's a whole raft of regulations which already exist that cater for that. And I'm fortunate enough as well to have Mark Follows, who I think some of you have met. Mark Follows is also from Glint. Mark, if you just put your hand up. Mark is the Chief Compliance Officer, and he's been instrumental in making sure that, Glint complies with all of these, since we have been enabling transactional gold in the US, where I think 70% of our customers actually reside. Since we started, must be nearly 5 years ago in 2019. So, Mark, can you just give
back and maybe you could share with
Yeah, Mark, could you just
can you hear me?
Yeah, could you just give a little bit of a flavor about what I'm talking about to the team, and just kind of touch on some of the regulations, the Regulation E and UDAP and stuff like that?
Yeah, well, what Jason's touching on is effectively compliance as a topic is as broad and as deep as you can imagine. It covers areas of risk management. You've got, what I would call the pedestrian, so the evergreen compliance areas, such as, money laundering rules, etc. But increasingly, today, what's important to understand is what do we mean by security? What do we mean by trust? And that breaks down into a number of areas. And Jason touched on, increasingly, especially in the US, we are under regulations that exist at the moment that are there to not just protect people's information, not just protect things like card data, not just protect the gold that sits in the vaults, not just there to protect the US dollar that's given to us in exchange for gold, but it's also about how we protect individuals. And that protection is against financial services firms that may cause wrongdoing or may cause harm or may have nefarious practices, etc. Which is why things like the Unfair Deceptive Abuse Acts and practices known as UDAP is important. Why Regulation E, which is part of the Electronic Fund Transfer Act, which was passed in 1978, is important. We sit under that as we operate payment cards. There's even current things at the moment, which is protecting seniors from financial abuse. So all of these are indicative of an approach which Glint are maturing, which is good news. This is something, as Jason said, a large proportion of our customers are active in the US. But these are requirements that sit on us. So the complexity of compliance covers a whole range of areas. It even goes down into marketing activities. But it's important for us to have a stewardship and to us to have the right approach and put customers and consumers at the heart of how we offer products and services. So it's more than just audits, of which, by the way, we sit under independent audits. We sit under rights of audit. It's more than just the reconciliations and the quality assurance and the quality controls. It's more than just the systems and controls that we have. It goes beyond that into even how we communicate, how transparent we are, And all of that is very, very important, because if you look at failings in firms, hidden charges, excessive fees, hidden margins on FX, all of these are problems that occur globally and continue sadly to occur. So yeah, I just wanted to unpack it from that lens.
And I think, sorry.
Yeah, so if I could, so Mark, the biggest question that I get on something like this is if we were to engage an alternate payment system, precious metals backed, it would likely be that we see a worsening in the value of the dollar. We see a worsening of financial conditions, that sort of thing, and the biggest concern I hear is, well, if the gold is in Switzerland or somewhere, then what security do we have if we were doing that system as a state? And the technology to know that if something were to happen to the Glint company, I mean, companies come and go, and if we were to do something like this as a state, how could we ensure continuity? So those are the two biggest things that I hear. It's that physical, having it be cited in Utah likely is a big concern, but then that continuity of being able to continue the process and the application. Jason, is that something you want to tackle?
Yeah, I mean, I think I studied architecture when I was younger, and I think I got quite good at developing briefs, and you've got to listen to the customer and look at what the needs of the customer are. And of course, Glint at the moment, we use a vault in Switzerland, and we've got staff and teams and infrastructure distributed all over the world. But I think it's very much understanding the needs of the state mean that really ideally what you want is a silo within the state. So you're very fortunate in Utah that you have a world-class vaulting company in Utah, just around the corner, not far from where you guys are sitting right now, run by Brinks, one of the biggest and most famous custodians, trusted custodians of precious metals in the world. They've got a phenomenal vault not far from where you are. Of course, even the source of gold has been discussed on the call today. Even that source is to a degree guaranteed, because you can get production of gold in your state, and there's absolutely no reason why a technology stack, whether it's Glint providing the solution for you, or if someone was able to do it, somebody else, that stack of effectively technology, the servers, the people running it, even the office, could all be in Utah. I think that ultimately that's what should happen. And I think that means that whatever is going on, you've got insulation you've got independence and security and insulation just by doing that.
And can I just add as well on your second point, in terms of resilience, yes, it's a truism. All private companies are at various whims at any point in time, but we have mechanisms in place. Those mechanisms can range from having, plans in place. So if we see any negative headwinds, we can react, and always to the betterment of the customer. And don't forget, it's the customers own the gold. So, this isn't a case of Glint owning that gold. We just hold a record of ledger. It's direct ownership. So, and the primary concern and primary objective is to always make customers whole. Should to use your analogy, should there be any continuity issues, part of being a responsible firm is seeing those problems ahead of time, and have measures in place.
So I guess for the group, any questions on if this were something we looked at, whether a payment system like this or another one, what types of security, escrow of technology, I mean, other things that we would need to think of?
And if I could just, I don't know that I have an answer to that question, but I appreciate the discussion and focus so far on this task force and the agenda. The conversation we just had about capital gains seems to me that perhaps in order for us to make a legitimate claim on this in court, we're not just gaming a system with a different set of assets. We have to kind of commit to this system in a real way as a state. Otherwise, we're just, it just seems like it will be treated superficially. And I think we need to be also exploring in this task force the downsides of that. I mean, it's been interesting to explore the possibilities and the reasons why. I mean, I don't dispute any of the inflation, the spending, the debt. It's very troubling. But if we were to truly go in this direction, assuming that it's feasible, as we, this a great company. Again, I think the state's got to go there, and then you have to look at what is that happen if the state really makes a commitment in this direction. Does it put everybody who doesn't commit to this at an even bigger disadvantage? So are we creating a bigger disadvantage for citizens who don't open an account based in gold and don't pay in gold? Is the state going to commit to that gold, and then do my taxes then, if I pay them in this traditional currency that is, not doing so well, does that make my obligations go up greater? Does it exacerbate, inflation in some way? I mean, I just think we have to look at what it means to have, can we have one foot in one boat and one in the other? Do we have to make a commitment? If we make a commitment, what impact does that have? And for example, and what is this kind of a structure have on our fractional reserve banking system? Of course, I represent the Utah Bankers Association, but I mean, if we are incentivizing and because the state has gone to this, so then there's an incentive for citizens to move to this so that they can make those payments and stay up with the state, and everybody who doesn't is operating at a disadvantage, and so they move more toward an account like this, and it's based in gold. Well, what does that do to our deposits in our banks and our ability to lend and grow our economy? Because ultimately, I think the only answer in this whole conundrum of debt and deficit is ideally economic growth. And I mean, it's a part of the answer. Obviously, we have to have some discipline when it comes to spending, but growth is a huge part, especially growth as a state. We as a state growing faster than other states and faster than the country as a whole can create a huge advantage for our constituency that way, but not if we're incentivizing and even penalizing people if they don't move their money into a gold-based account, which then can't be lent through our fractional reserve banking system into our own economy and be creating jobs and building businesses. So, I don't want to make it worse for Utah citizens, and I don't know, I'm not concluding that we would. I just feel like this task force has an obligation to explore the downsides of all of this, as well as the potentials and the opportunities and the motivations to do it.
I think those are all excellent points, and yeah, I'd love to dig into those offline more, but I've had some of these questions with Jason before. Jason, if you want to try to tackle some of those, downsides of a precious metal system, does it create inequality? Would it exacerbate penalties on people that choose not to use? What impact on a banking system? What impact, positive, negative, on economic growth? Does it negatively impair or even curtail the ability for lending and traditional banking?
Yeah, so
they're all great questions.
yeah, I think they are, and they're ones we've heard before, and I think that they're all good questions. So let's just take, first of all, the fact this is just a choice. And it's a choice between obviously the incumbent currency, the US dollar, and a new gold-based one, which the gold-based one for the time being is going to be the most volatile, isn't it? Yeah, everything's priced in US dollars. Inflation is not out of control, which is great. And you know, I really hope that growth can get us out of the huge debt problems. Wouldn't it be wonderful if artificial intelligence and other technologies allowed productivity to get to the point where the $35 trillion and increasing worth of debt could be brought under control? That would be great. And wouldn't it? And if that all happened and things all calmed down, then you know, I'd be very happy to retire. But this is just about a choice to have a second option. And should you know, gold's about security. Should things get worse, then wouldn't it be a good idea to have this extra choice? And so certainly we see with Glint that we don't have our customers in the US putting all of their money into Glint. Of course, they only put a portion of their funds and their savings into Glint, and they spend it sometimes. It remains effectively the second choice behind the dollar, whilst the dollar is still the predominant currency. And absolutely, at the end of the day, this is not about trying to damage the dollar. It's actually trying to support the economy and therefore the dollar and the government and everything it represents. The other thing is that, you know, we very much need, I think the system needs to work with the banks. And in fact, a system like Glint has to work with the banks. There is a bank that we work with at Glint, the card that is produced that allows people to spend in US dollars, by the way. So a lot of the merchants can receive at the moment, you know, they receive their funds in US dollars. That is issued by a bank. And it's through that relationship with the bank that I said before that that Glint becomes in scope with most of the regulations that we were talking about before. And so and there's absolutely no reason why the banks can't have this choice that we're talking about in their own banking apps. You know, the Glint app that you see on your phone, for instance, communicates to the back-end system through an API. Banks could do that too. In other words, you could have a variety of integration with banking apps. In Europe, there's a big evolution of what's called open banking, when this is happening all the time with different products being integrated into banks' apps. And so the banks actually, I think, should be looking to embrace this and say, you know, at the moment, 18% of all Americans think gold is the most important investment. So the money is already leaving their accounts. And that's not just that's, you know, you've seen Costco, people buying gold, for instance, and things like that. That money is leaving the banks at the moment and is going into gold. I don't know what the percentage is, but I think I've seen another stat about 45% of Americans own gold. The World Gold Council's got some great stats on this. There's a whole percentage of people who are thinking about buying gold. That money's already leaving it. Wouldn't it be a good idea if it was, you know, backed by the state with the possibility potentially of capital gains going away with it? It was audited. Its rights for citizens to be able to use it as money were protected by the state, and the banks embraced it and integrated with it. So they actually had a little bit more control around the narrative and around the use of this currency. Then the Utah state beehive gold currency, whatever you want to call it, could be in every bank's wallet. There's no reason why it just has to be on a platform like Glint. A platform like Glint can integrate into all of these banking apps. And then, of course, you come to lending. Well, a lot of people, some people don't want to spend their gold. You know, they think the gold's appreciating so much, and you know, let's just save it. And well, what I'd rather do is I borrow some money against my gold. That's collateralized gold lending. And so the banks, of course, could also take a great role in lending money to people against their gold holdings. And I mean, that could go on. The list could go on. I think there's a really great conversation to be having with the banks. We're starting.
I would suggest an offline meeting to drill down on these specific issues and then maybe report back in the September meeting. Because, and first of all, let me just say, Howard, that the fact that you're here and at the table in the discussion is phenomenal. It really is phenomenal that looking at how we do integrate and the things that you said were spelled out in the bill, right? How we how we make sure we explore growing the economy and securing the economy. And so I really want to applaud you for being at the table. I know that in some states, when they talk about these things, the Bankers Association just shuts off, so we don't even want to talk about it and hear it.
No, that's
And
not
but no, I really want to applaud you for doing that. The one thing that comes to mind is, remember California? It was maybe a decade and a half ago that they couldn't pay their bills, and so they just issued a California script, and they just gave them like a little California, and they did that in the Depression as well. That you had states and communities just giving out little kind of pieces of paper to substitute as money. And hopefully, but man, the trajectory on the dollar, when we were talking to Thomas Honig, he was like, if they don't come to some kind of fixed standard, all the trajectories just look really kind of painful, and we end up with a script or something that's backed by nothing. But I'm excited to follow up with you offline if you're willing, and anybody else that wants to drill into that. And I think any other kind of downsides, we ought to really take a hard look at that and look at coming back in the September meeting. Any final comments, questions today? Yeah.
Just process wise, I know when I go back to the bill, there's really two things that it contemplates. One is the investment side as a state of Utah entity, the investment side, which I know we talked about, and then one is changing monetary policy for the public. And I know most of our discussion has been focused on that, which is great. But I know one of the things we're tasked to do, or the treasurer's office is tasked to do, is to make recommendations on legislation by October.
Right.
I know we have one more meeting left, and I'm happy to weigh in on some of that missing framework at least on the investment side of what can be put in place. But I do think it would be helpful for the group to maybe hear what might be proposed, or what maybe you haven't even gone that far yet.
No, that's a great idea. And we've been having line meetings on refiners and brokers and all of that. Marlo, I know we're over time, but do you or Kurt want to kind of give an update on the investment side, and then I think coming to the September meeting, because we are getting very short. Scott Elder, you're on. I would suggest that we have a legislation discussion meeting offline, and Scott and anyone that's interested in that, I'll email out and we'll find a date and do that ahead of September meeting as well, and then we can kind of walk through some of those things. But I appreciate you kind of getting us focused on time. I think the idea is to have maybe a meeting before the October report, because in the bill we report to the interim committee at the October meeting, which would be the third Wednesday. So if we have our September meeting, let's see where we get with that. And then maybe if we need to have one more before the interim meeting. But you guys want to talk about the status of the investment side of the bill?
Yeah, so.
Does that take care of that? Is that?
Yeah.
Okay.
Yeah, so we've had some great discussions actually today with Speaker and the President, and just talking about how we might go about purchasing physical gold and the ongoing costs. And so there's some educational elements that I think might be helpful for folks, but in general, there's very good support for moving forward with this, and we really are fortunate in Utah to have like a Brinks facility already here, and a lot of this is it's new to people, and so it feels a little bit different, but it's a very deep market, and a very liquid market, global market. And a lot of central banks are increasing their activity in the market, and so that really is it paves the way for a state like us to do very similar things, and really a lot of the accounting and the valuation. It's like a traditional asset. It's just, you know, you're taking a value spot market price and, you know, doing the accounting, and it's pretty standard. You've got audits and, you know, insurance. It might be a little bit different because you're actually counting beans and bars and things like that. So, I think we're making good progress there.
Yeah,
You wanna add anything?
no, I'm just wondering if would it be helpful to share some of these things out with the committee?
Yeah, I think we could probably send that out with them.
So- Kurt has done a really good job on kind of going back and looking at performance of gold with inflation, with the PTIF and some of those things. And then we've had meetings with, oh my gosh, half a dozen or so brokers and others, and it's been really fascinating. But it's kind of come down to gold is gold is gold, as long as you have it authenticated, get the best price. And we've kind of heard that from a lot of them, you know, through the discussions. And so now it's been interesting with Marlo. You know, we've been kind of looking at this and drilling in on this, but you know what bringing 104 legislators along is like. And so making sure that they have the same opportunity to know that we don't take a red wagon on the street and hold out the cardboard sign to sell gold when we need to liquidate, and just helping them understand the mechanics. So, but yeah, really positive meetings today, and the discussions were to look at kind of dollar cost averaging or just tranching out the positions over a period of time. We're still trying to look at what that period of time is, but then it's kind of working into it. And then there's some pieces in the legislation that we need to do next year for how the costs are accounted for, because it's not like the typical investments where they take off the interest and use the interest in the general fund. And so we need to deal with some of those issues in legislation. And
I'd love to help weigh in on that as you guys put it forward.
That'd be great.
yeah, no, and same thing, really grateful that you're involved and understand the legislative process, and certainly the role with the government. I think before anything does move forward, we want to make sure that you and anyone else in the governor's office understands and where that's going as well. So today was just the first meeting with the speaker and the Senate president. So yeah, let's see if we can set that up with you and anyone else
Right.
in that office. So
Yeah.
no, I'm glad you brought that up. Any other comments, questions? I make a motion that Marlo springs for pizza next time.
Thank
Other than
you,
that,
everybody.
Thank you, everyone. This is extremely helpful. I've got bank and challenge offline meeting, legislation offline meeting, and then mining, and that also ties in with the legislation meeting, Brian, that we can kind of drill down on. So, and then the other thing that we talked about today was trying to schedule a tour to the Brinks Vault so that everyone can go have a look and see that. So we're working on trying to schedule that.
Yeah.
Anything else?
That's it.
All right.
I was thinking, Ken, I don't know if it'd be possible if we could be ready by September to maybe bring some legislative discussion items to this group.
Yeah, I think that's the idea. So Scott
Yeah.
is one of the very best, and this is a priority for me. So we'll want to schedule that legislative follow-up meeting early in September.
Yeah,
And I'll
that
send
makes
out
sense.
some potential dates and yeah, Scott's very, very good. We have one of the best drafters working with us, so we'll be in good shape.
Great.
Awesome.
All right, thanks, guys, and
Thank you.
really appreciate all the input and help.